The Valley Current.
I want you to imagine a war, but not, a conventional war.
Right, yeah, like a corporate war.
Exactly. A war fought between two absolute titans of industry. And the battlefield isn't a marketplace, and the weapons aren't like billion-dollar marketing budgets or primetime commercials.
It's all happening entirely in the shadows.
Right. We are talking about secret cloud servers, off-the-record job interviews in unmarked buildings, laptops that mysteriously never get returned to IT, and hidden, encrypted messaging apps.
It's basically the ultimate modern corporate cloak and dagger scenario.
It really is. And the prize they're fighting over isn't territory or even necessarily user data. It's, something far more scarce.
Which is exactly why we're unpacking this today.
Yeah. So we got our hands on a truly fascinating breaking legal briefing provided by Jack Russo at Computer Law Group, LLP, or CLG.
It's a wild read.
Oh, totally. This briefing breaks down a massive lawsuit filed on July 10th, 2026. So in one corner, you have Apple, a $4.6 trillion incumbent, like the oldest, most entrenched money in modern tech.
The biggest of the big.
Right. And in the other corner, you have OpenAI, an $852 billion pre-IPO challenger that has just completely upended the global conversation over the last few years.
Yeah, they really have.
And so Apple is suing OpenAI in federal court for trade secret misappropriation.
And, the stakes here are almost impossible to overstate. When you look at the raw numbers, you might think, oh, this is just a legal squabble over a few lines of proprietary code, right?
Yeah, or maybe like a patent dispute on a microchip, which happens, all the time.
Exactly. But if you connect this to the bigger macroeconomic picture, this is a battle for the absolute most scarce resource on the planet right now.
Human talent.
Human talent.
Which is just wild to think about. With all the automation and AI out there, the bottleneck is still like actual human beings.
It is. Specifically, the highly specialized AI, artificial general intelligence, and artificial superintelligence hardware talent.
Right, the hardware side.
Yeah, it's this very small pool of human minds that will basically dictate which of these two companies, if either of them, honestly actually survives to see America's 300th birthday in 2076.
50 years from now. That's the timeline we are looking at.
It's huge.
But, before we get into the downloaded files, the alleged hidden messages, and this crazy story about a secret supplier sting operation, we have to lay down some absolute ironclad ground rules for this deep dive.
Yeah, this is absolutely critical for anyone listening. What we are discussing today is based entirely on a legal complaint filed by Apple.
Right. Just the complaint.
Exactly. Every single factual assertion we discuss from that document is an allegation only. Nothing has been proven. Nothing has been adjudicated in a court of law.
Not a single thing.
Right. In fact, no defendant has even filed an official legal answer yet. OpenAI has publicly and vehemently denied all wrongdoing, stating on the record, we have no interest in other companies' trade secrets.
And it's not just the companies, right? Because the briefing names specific people, and we have to be really clear about them, too.
Yes. All individuals named in this complaint, including the two primary individual defendants we will discuss, Chang Liu and Tang Yutan, as well as anyone else mentioned in this narrative, are presumed completely innocent of all alleged misconduct.
100%.
Our goal here is not to play judge, jury, or executioner. We are just analyzing the incentive structures, the complex legal frameworks, and the strategic chess moves outlined in the CLG briefing.
We aren't taking sides at all.
No, not at all. We're just looking at the machinery of what might be like the most unprecedented legal battle of the decade.
Yeah, so I was reading through the background of this briefing,
Yeah.
and to understand the specific allegations, I feel like we first have to look at the macro-level talent war that sparked this whole thing.
Oh, absolutely.
The briefing calls it the trillionaire versus trillionaire labor war.
Okay.
Because this didn't just happen overnight. It all seems to trace back to a very specific moment in time, like October 2025.
And what's fascinating here is the sheer synchronicity of that exact time frame.
Yeah, it's wild.
According to the briefing, October 28, 2025 was a historic day for both of these entities. On that exact day, Apple crossed the $4 trillion market cap threshold.
Which is just staggering wealth. It's an unfathomable amount of resource consolidation.
It really is. But on that very same day, OpenAI completed its highly publicized restructuring into a public benefit corporation.
Oh, right.
Yeah, they officially shifted away from their original nonprofit ethos, and they hit an $852 billion private valuation by the spring of 2026.
Wow.
And they did this as they were gearing up for a massive initial public offering.
Okay, so let's play this out from a business perspective. You have OpenAI, which is practically printing headlines. They are, the hottest name in tech.
Oh, for sure.
But behind the scenes, training these frontier models, they are burning cash at a historic, unprecedented pace.
Like unbelievable amounts of money.
Right. They need to show tangible results to their investors before an IPO. And specifically, they need to show hardware results. They need a device. So what do? They go shopping.
They do. In May 2025, OpenAI acquired a company called IO Products for roughly $6.5 billion in equity.
Okay.
Now, the context here is crucial. Who founded IO Products? It wasn't a group of scrappy college dropouts.
Definitely not.
No, it was founded by absolute elite former Apple executives. We're talking about people like Jony Ive, the legendary designer behind the iPhone.
Oh, wow, Jony Ive?
Yeah, and Tang Yu Tan, who was a vice president of product design at Apple for over 2 decades.
That's a huge gap.
Huge. So OpenAI absorbs this company, Tang Tan becomes OpenAI's chief hardware officer, and suddenly OpenAI isn't just a software company anymore, they are building a consumer device.
Right. The reports talk about a screenless, pocketable, ambient computing companion, a totally new paradigm.
Exactly.
And to build it, to actually manufacture this thing at scale, Apple alleges in their complaint that over 400 former Apple employees are now working at OpenAI. 400.
And that number, 400 human beings migrating from one campus to another, is the beating heart of this entire conflict.
I mean, that's an exodus.
It is. And if we zoom out and look at the historical context, every single industrial revolution is built on the migration of human knowledge. It never, stays contained in one place.
It's a history of innovation, right? People learn things and take that knowledge somewhere else.
Exactly. Think about the first industrial revolution. It was essentially built on appropriated British know-how.
Okay, how so?
So a man named Samuel Slater memorized the highly complex designs of British water-powered textile mills. Now, at the time, Britain had made it a literal crime to export these designs or for textile workers to emigrate.
Wait, really? A crime?
Yes, they wanted a total monopoly on the technology. But Slater memorized the plans, immigrated to America in secret, and built the first successful water-powered mill in Rhode Island.
No way!
Yeah, the British press literally called him Slater the Traitor.
Slater the Traitor. That is amazing. So the idea of a company or a country trying to lock down human knowledge is nothing new.
It's history rhyming. Fast forward to the third industrial revolution, the digital age. Silicon Valley itself, the entire ecosystem we know today, was founded by the traitorous 8.
Right, I've heard of them.
Yeah, these were brilliant engineers who walked out of Shockley Semiconductor in 1957 because they were frustrated with management, and they founded Fairchild Semiconductor.
I was started everything.
Exactly. The entire culture of the Bay Area is built on this premise. People leaving incumbent, slow-moving giants to start nimble challengers.
That's just how it works.
Right. And now, as we enter what many are calling the 6th industrial revolution, the era of AGI and artificial superintelligence, the most scarce, valuable asset isn't coal or electricity or even silicon wafers.
It's the people.
It is the very small population of human minds capable of building the hardware architecture for these frontier models.
I hear that, but I'm putting myself in Apple's shoes right now. If hiring away talent is a tale as old as time, and if Silicon Valley is literally built on it, why is Apple suing?
Well,
if I'm running a $4.6 trillion company and my top hardware guys are leaving to join a rival, why not just enforce a non-compete agreement? Just point to the contract they signed and say, sorry, you can't work for a competitor for 2 years. Problem solved.
because they legally can't.
Wait, what?
Yeah, and this is a massive piece of the puzzle. Apple is a California company. OpenAI is a California company. And California law, specifically Business and Professions Code Section 16600, completely and utterly forbids non-compete agreements.
I had no idea it was that strict.
Oh, it is ironclad. This isn't a new trend. It's a foundational law dating back over a century. It guarantees nearly absolute employee mobility in the state. You cannot legally trap an employee at your company, no matter how much you pay them or how important they are.
Wait, really? So if I'm Apple, I just have to sit there and watch an exodus of my top-tier, highly trained hardware talent head straight for a newly minted rival, and my hands are completely tied behind my back.
Yep.
That seems incredibly frustrating for a company that pours billions into research and development.
It is deeply frustrating for employers, but it's the conscious trade-off California made to foster a dynamic, fast-paced tech economy.
Okay, so what do they do?
So because Apple cannot legally stop the talent from moving, they are forced to change their strategy. They have to convert what is essentially a talent war into an evidence war. Trade secret law becomes the absolute last guardrail allowed by California's fiercely pro-mobility regime. The rule is essentially this. You can take your general skills and your native intelligence to a new job, but you absolutely cannot take your former employer's specific proprietary secrets.
Got it. I was trying to think of a way to visualize this line between general skill and trade secrets.
Sure, go for it.
So if a professional football team hires away a rival star head coach, that's just considered good business, right? The coach has plays in his head. He knows how to motivate players. He understands the mechanics of the game better than anyone. He takes all that skill to his new team. That's legal. But in this case, Apple is essentially claiming OpenAI didn't just hire the coach. They're alleging that OpenAI demanded the coach sneak into the locker room, take the rival team's actual physical printed playbook, and bring it to the job interview.
That's a great analogy.
But how do you practically separate the coach's innate skill from the proprietary playbook? It's all jumbled together in their experience.
That is the multi-trillion-dollar question, and it's the core tension of this entire lawsuit. The law attempts to draw a very rigid line. General skill, experience, and knowledge belong to the employee.
Okay.
Specific proprietary secrets formulas, customer lists, unreleased blueprints, those belong to the employer. California courts are so protective of the employee side of this line that they've explicitly rejected something called the inevitable disclosure doctrine.
What is that? The inevitable disclosure doctrine?
Well, in some other states, an employer can go to a judge and argue, Your Honor, this employee knows so much about our top secret future plans that they will inevitably disclose them if they go to work for a direct competitor. It's impossible for them not to use what they know.
And that works.
In some states, a judge will grant an injunction based on that. But California says absolutely not. You cannot get an injunction against a former employee just by arguing they might use a secret in their head. You have to prove actual physical misappropriation or an active threat of it.
Which means you need a paper trail.
Exact.
You need hard, undeniable evidence that something tangible was taken. If you can't police what's in their minds, you have to police what's on their hard drives.
Precisely. And that necessity for hard evidence brings us directly to the highly specific, alleged evidentiary trail that Apple claims to have uncovered.
Right, let's dive into that.
Yeah.
The CLG briefing highlights two specific defendants to illustrate how Apple is trying to prove this extraction of hard evidence. Let's start with the first one. Chang Liu. What is the story there?
So, according to the complaint, Chang Liu was a senior system electrical engineer. He spent 8 years at Apple working on deep hardware integration before he left to join OpenAI in January 2026.
Okay, 8 years is a long time.
It is. And Apple alleges that when his employment ended, he failed to return an Apple-issued work laptop.
Okay, that's a red flag right away.
Yeah.
I've left jobs before, and HR is usually pretty aggressive about getting the hardware back. Keeping a laptop is a bad look.
It's the first domino. But then the allegations get highly technical and much more concerning.
Oh boy.
Apple claims that Liu discovered a rare, previously unknown authentication vulnerability in their IT infrastructure.
Wait, like a back door?
Essentially, yes.
Yeah.
This vulnerability essentially granted him continued unauthorized access to Apple's secure cloud file repository long after his employment and his official access had supposedly been terminated.
And I'm guessing he didn't call the IT help desk to report this massive security flaw.
Allegedly, no. Instead, the complaint details a digital trail that, if proven in court, is absolutely devastating. Apple claims that Liu messaged a former colleague who was still working inside Apple, a woman named Alyssa Peng.
Okay.
And in this message, he allegedly said, LOL, I found out I can access the network storage. So funny.
LOL. Are you kidding me?
Yeah.
The hubris of texting LOL while allegedly breaching a former employer's secure server. But wait, how does Apple even have the text of this message? If he left the company, wouldn't he be texting from his personal phone?
This is a crucial point of pleading craft that Jack Russo highlights in the briefing. Apple has these messages because they were allegedly captured on Apple-issued work devices. Yeah, the defendants were allegedly using company-owned hardware on company networks to discuss unauthorized access to company servers.
Oh, wow. So Apple owned the device, which means they owned the logs. They didn't even need a subpoena to get that initial thread. They just looked at their own IT data.
Exactly. It solves a massive evidentiary hurdle for Apple right out of the gate. They have the defendant's own words on their own equipment.
Unbelievable.
So what did Liu allegedly do with this unauthorized access? Apple claims that over a period of several weeks, importantly, while he was already actively developing hardware for OpenAI, he downloaded dozens of highly confidential files.
Like, how many are we talking?
Well, we aren't talking about a few loose PDFs. Apple alleges he downloaded a compilation exceeding 1,000 pages of technical files.
1,000 pages.
Yes, which included a highly detailed proprietary presentation on the manufacturing and testing of main logic boards.
1,000 pages on logic board manufacturing. I mean, the logic board is basically the brain of the device. That's not just a passing glance at a document to refresh your memory. A 1,000-page download is an extraction operation.
It really is.
And he didn't just stop at downloading the files for himself, did he?
No, the allegations go much further. Apple claims Liu actually coached Alyssa Peng, who, again, was still inside Apple's firewall on how to evade Apple's security team when she was copying files.
Wow. He's running an operation.
Allegedly, yes. He allegedly directed her on what specific confidential material she should study and copy to prepare for her own upcoming job interview at OpenAI.
That is wild.
And perhaps most damningly, recognizing the risk of being caught on Apple servers, he allegedly told her they needed to move their conversations off of Apple devices entirely and onto the Line messaging app to hide their tracks.
Moving to an encrypted third-party app. I mean, I'm not a lawyer, but that feels like the definition of a cover-up.
In legal terms, it's incredibly significant. It establishes what courts call a consciousness of guilt or willfulness.
Right.
It shows that he allegedly knew what he was doing was prohibited, understood the surveillance mechanisms in place, and took affirmative, calculated steps to conceal his actions.
So no oops defense.
Exactly. This completely destroys any defense of, oh, I accidentally clicked download on my personal photo album and got some work files mixed in. It's alleged to be a calculated exfiltration.
So that's Liu, a mid-level engineer who allegedly found a backdoor and took advantage of it. But the second individual defendant named in the briefing is a much, much bigger fish. Tang Yutan.
Yes. Tang Tan is not a mid-level engineer. He was a 24-year veteran at Apple.
24 years.
He served as the vice president of product design for major product lines, including the iPhone and the Apple Watch. He is now the chief hardware officer at OpenAI.
Okay, wow.
To put it in perspective, Apple entrusted him with their most sensitive future projects, their multi-year roadmaps, and their most trusted billion-dollar partner relationships in the supply chain.
The guy is hardware royalty, so what are the specific allegations against him?
The complaint alleges that Tan used Apple's internal, highly secretive project codenames during job interviews he conducted at OpenAI.
Oh, wow.
Yeah. He was allegedly using these codenames to solicit highly confidential information from candidates who are currently employed by Apple, sitting right across the interview table from him.
Just casually dropping code names.
Right. He was allegedly probing them about the current status and the engineering challenges of unannounced Apple products.
Okay, that's bold. Using the secret language of your old company to extract updates from your current recruits.
It is bold, but the most striking allegation against Tan is physical.
What do you mean?
Apple claims that Tan explicitly directed job candidates to bring actual parts, and the complaint lists things like prototype batteries, systems in package, main logic boards, and customized shields to their OpenAI interviews.
Bring physical parts to an interview.
Yeah, for what he allegedly called show and tell sessions. The complaint even quotes one candidate who was apparently so surprised by this request that he remarked to OpenAI recruiters he didn't even know we could take those from the office.
Okay, wait. I want to push back on this a little bit on behalf of the listener, because this feels like it touches on a really gray area in the tech industry.
Okay, let's hear it.
Isn't bringing a portfolio of your past work to an interview completely standard practice? If I'm an architect, I bring my blueprints. If I'm a UX designer, I bring my wireframes.
Sure.
If I'm a hardware engineer who just spent the last 5 grinding years designing a microscopic battery to be 2% more efficient. Isn't it completely normal to bring that battery to an interview to show what I can physically do? Where is the line drawn? Is it strictly at unreleased hardware?
It's a fantastic question, and it is exactly the gray zone that this entire lawsuit is going to have to litigate. The CLG briefing addresses this tension directly.
Okay, what do they say?
Under California law, as we discussed, you own your general skills and your experience, but your employer unequivocally owns its stuff. Bringing a shipped, publicly available iPhone that you worked on, setting it on the table, and talking generally about the methodologies you use to improve the battery life. That is usually entirely within the lawful general skills zone.
Right. You're just saying, I'm great at making batteries smaller, and here is a product on the market that proves it.
Exactly. But bringing physical prototypes, unreleased test parts, or confidential CAD files that are the legal property of your employer, that crosses a massive legal line.
It's theft, basically.
It goes beyond trade secret misappropriation and into actual conversion of property. Conversion is essentially the civil law cousin of theft.
Gotcha.
Even if that specific prototype battery doesn't happen to contain a legally definable trade secret, maybe it's just a standard battery in a weird shape. It is still physical property belonging to Apple.
It's their physical thing.
Yes. The briefing makes this distinction very clear. Hardware created on your employer's premises with your employer's materials is your employer's property. Walking out the door with it in your backpack is a massive red flag.
Okay, that makes a lot of sense when you break it down like that.
Yeah.
It's the difference between describing a play from memory and stealing the physical binder that belongs to the team.
Exactly.
So Apple has these individual allegations lined up. Lou with the massive digital downloads and the encrypted chats, Tan with the physical prototypes at the interview table. But Apple didn't just sue 2 guys.
No, they didn't.
They sued OpenAI as an entire institution. They're claiming this wasn't just a couple of rogue employees acting out of line or getting overly enthusiastic in an interview.
Exactly. Apple is trying to paint a picture of systemic, top-down institutional complicity.
Like it was planned.
Yeah. They are alleging that OpenAI's leadership intentionally architected this extraction of secrets. They claim OpenAI structured its entire recruiting and onboarding process specifically to elicit and absorb this confidential information.
How so?
For example, the complaint alleges that OpenAI required Apple candidates to give technical deep dive presentations during their interviews.
A technical deep dive.
Yeah.
Ironically, what we are doing right now.
Yes, but in a very different context. OpenAI allegedly provided mandatory slides for these presentations, specifically asking candidates to provide CAD design artifacts and demanding granular step-by-step details on vendor selection and system integration methodologies used at Apple.
Which means they aren't just sitting down and saying, tell us about your strengths and weaknesses.
No, not at all.
They're saying, give us a detailed slide-by-slide presentation on exactly how Apple builds its supply chain and integrates its components.
Precisely. And the institutional allegations go even further into the offboarding process the moment an employee actually leaves Apple.
Okay, what happened there?
Apple claims that Tang Tan retained a highly confidential internal document from Apple marked Need to Know. This document was essentially the playbook detailing Apple's exact security protocols and forensic procedures for departing employees.
Like how Apple's IT department checks your laptop, what they look for in your email history, what logs they pull before you walk out the door.
Exactly. It's a blueprint of the security system.
Oh, wow.
And Apple alleges that OpenAI didn't just passively possess this document. They allegedly circulated it internally to new hires from Apple as a checklist that Tang put together.
You're kidding.
Nope. They allegedly rebranded Apple's own security document, and they used it to coach incoming recruits on how to evade Apple's exit forensics, allegedly telling them to avoid the dreaded walkout and to refuse to sign standard exit paperwork, acknowledging they had returned all property.
That is just incredible if it's true. It's like breaking into a bank by having the former head of security hand out the guard's patrol schedule and the camera blind spots to your crew.
It really is.
But reading through the briefing, Jack Russo points out that the single most dangerous allegation for OpenAI isn't about recruiting or laptops or offboarding checklists. It's about a sting operation involving a supplier.
Yes. The metal finishing sting. This is where the allegations move from the digital realm into the physical, heavy industry supply chain.
Break this down for me, because this part read like a corporate spy thriller.
So, Producing consumer hardware at the scale of an iPhone or an Apple Watch requires absolute mastery in industrial design and manufacturing.
Right.
The look, the feel, the precise finish of the metal on those devices is not off the shelf. It is a highly proprietary, multi-step technique developed over years of trial and error.
Okay.
Apple alleges that OpenAI, operating through its hardware subsidiary IO Products, approached one of Apple's trusted, highly vetted, exclusive industrial design partners.
We're talking about a third-party factory somewhere in the supply chain that Apple contracts with.
Yes. A partner that handles this specific metal finishing process. And Apple claims in the lawsuit that OpenAI actively induced this partner to perform Apple's proprietary metal finishing technique for OpenAI's benefit on OpenAI's prototype devices.
Oh, wow.
And the kicker, the really legally dangerous part. Apple alleges OpenAI actively misled this partner into thinking Apple had consented to this shared use of the technique.
Whoa. Let me make sure I understand this. It's like, imagine a rival restaurateur sneaking into the back of a Michelin star kitchen. They look at the exclusive butcher delivering the meat, and they say, hey, the head chef here told me it's totally fine for you to prep his secret proprietary cut of Wagyu beef from my new place opening down the street. Just put it on my tab.
Exactly.
If that is true, that is not just passive hiring of talent. That is an active orchestrated heist of a physical manufacturing process.
That analogy is absolutely spot on. And legally, why does the CLG briefing highlight this as the most dangerous liability for OpenAI? Because unlike a conversation in a job interview, this doesn't rely on a former employee's blurry memory of who said what.
Right, there are receipts.
It involves a third-party supplier. That supplier has their own email servers, their own work orders, their own invoices, and their own witnesses who can testify about what OpenAI told them.
Physical proof.
It involves physical, metal finished products sitting in a factory that can be subpoenaed, photographed, and examined by a judge. Furthermore, it involves an allegation of affirmative deception, lying to the supplier about Apple's consent.
Which is huge.
Yeah. Under trade secret law, affirmative deception automatically satisfies the requirement for improper means of acquiring a secret, completely independent of whether anyone signed a non-disclosure agreement.
It's hard, physical, third-party evidence. It takes the whole he said, she said element out of it.
Exactly. And to make matters infinitely worse for OpenAI's legal defense, Apple alleges that they sent a formal written warning letter to OpenAI in February 2026, months before filing this massive lawsuit.
Oh, they warned them first.
Yes. Apple said, we have serious concerns about these activities. Please investigate this internally and stop. And Apple claims OpenAI completely ignored the letter for 5 months.
Which just looks terrible to a judge. You were formally warned, you were put on notice, you ignored it, and you allegedly kept doing it.
Right. It massively bolsters Apple's argument that OpenAI's conduct wasn't an accident, but was willful and malicious.
Wow.
And because Apple views this not as a past wrong, but as an ongoing active heist that threatens the core of their future hardware business, they needed a legal strategy designed to stop the bleeding immediately.
Because time is of the essence.
Right. They don't want to wait 3 years for a jury to slowly review the evidence and award them a pile of cash. By then, the damage is done. They need to slam the brakes on OpenAI's hardware division right now.
Which brings us to the legal chess match. And this is honestly the part of the TLG briefing that completely blew my mind because it is so counterintuitive.
It's fascinating.
Let's look at the facts. Apple is a California company. OpenAI is a California company. The individual defendants live in California. The alleged theft, the downloading, the interviews, it all happened in California. But Apple explicitly, deliberately decided not to sue under California state trade secret law.
It is a brilliant, highly aggressive, and extremely calculated strategic move by Apple's legal team.
So if they aren't using state law, what did they do?
They filed their complaint exclusively under the Federal Defend Trade Secrets Act, or DTSA, alongside some standard breach of contract claims. They deliberately and entirely skipped filing under the California Uniform Trade Secrets Act, which is known as CUTSA.
But why? I mean, California has to have incredibly robust trade secret laws. Given that Silicon Valley is there, why ignore your home state's powerful laws when you were sitting right in the middle of Cupertino?
Well, Jack Russo outlines 5 distinct, highly technical reasons for this in the briefing, and together they form a masterclass in modern litigation strategy.
Yeah, let's hear them.
The first reason is a concept CLG refers to as supersession hygiene.
Okay, we need to unpack supersession because that sounds like a terrible sci-fi movie about aliens taking over. What does that actually mean in a courtroom?
In California jurisprudence, CUTSA, the state trade secret law, acts like a legal black hole. It has an incredibly aggressive displacement doctrine.
Same way.
What this means is that if you file a lawsuit claiming someone stole your trade secrets under CUTSA, that specific claim tends to absorb and completely destroy any other related civil claims you might try to bring based on the same underlying facts.
Wait, really?
Yeah, so if you try to sue for conversion of property, or unfair business competition, or tortious interference alongside your trade secret claim, the judge will likely throw those extra claims out, saying CUTSA supersedes them all. You put all your eggs in one basket.
Ah, I see. So if Apple fails to perfectly prove the strict legal definition of a trade secret, they lose everything because the black hole swallowed their backup arguments.
Precisely. By completely skipping the state statute and filing under the federal DTSA, Apple ensures that its secondary claims like breach of contract for violating an NDA or conversion for taking physical prototypes remain totally safe and untouchable by that California black hole.
That's smart.
They keep their legal arsenal diversified.
That is incredibly smart. Okay, what is the second reason they went to federal court?
The second reason is about bypassing what's known as the Section 2019.210 gate.
The gate.
Yes. Under California civil procedure, before a plaintiff can ask the defendant for a single email, a single server log, or take a single deposition in discovery, they must first identify all of their allegedly stolen trade secrets in exacting, granular detail for the court.
Let me play devil's advocate here. Isn't that law there for a good reason?
It is.
It sounds like California is trying to protect employees and startups from frivolous lawsuits. It stops giant companies from going on massive phishing expeditions where they just demand to see a competitor's servers, hoping to find something they can claim as their own. You could have to know exactly what was stolen before you sue and demand to see the other guy's homework.
You are exactly right about the legislative intent. It was designed to protect defendants and prevent phishing expeditions. But in practice, in high-stakes litigation, it has become a defendant's favorite choke point.
How so?
It generates endless, agonizing arguments and motions. Apple will submit a list, and OpenAI's lawyers will argue, this isn't specific enough. What exactly is the secret in step 3 of the metal finishing?
Right, stalling.
Exactly. The judge has to review it, send it back. Apple revises it. This process can stall the actual discovery of evidence for a year or more. The case goes absolutely nowhere while they argue over definitions.
Wow.
But in August 2025, a crucial federal appellate ruling called Quintara decided that if you sue only under the federal DTSA and not the state law, you do not have to pass through this California statutory gate.
Oh, so Apple essentially bypassed the toll booth.
They did.
By avoiding CUTSA, they can launch straight into aggressive discovery. They can demand OpenAI server logs, depose Tan, and subpoena that metal finishing supplier immediately without spending 18 months arguing with a judge over the exact molecular definition of their battery technology.
Precisely. They bought themselves the most valuable commodity in litigation, speed.
Makes total sense.
Now, the third reason they chose federal court is arguably the most punitive, and it concerns contempt power. Let's say a court issues a preliminary injunction, an order saying to OpenAI, you must stop using these specific files immediately. If a California state court issues that injunction and the defendant violates it, state law severely caps the civil contempt penalty.
What's the cap?
It's capped at a mere $1,000 and up to 5 days in county jail per act.
$1,000. Are you serious?
Dead serious.
To a company like OpenAI, which is valued at $852 billion, $1,000 is literally less than a rounding error. It's the lint in their corporate pocket. If I'm OpenAI and I need this hardware to launch, I would pay $1,000 all day long to keep my engineers working on those files. It's the cost of doing business.
Exactly. In state court, the fine for defying a judge is essentially a cheap parking ticket to a billionaire. It has absolutely no coercive teeth.
Right.
But federal courts are an entirely different animal. Federal judges have uncapped coercive civil contempt power. If a federal judge issues an injunction and OpenAI ignores it, that judge can fine them $10,000, $100,000, or $1 million a day until they comply.
Wow.
In federal court, the judge doesn't hand out a parking ticket. The judge holds a detonator to the company's entire bank account. The penalty is whatever it takes to force absolute compliance.
So let me summarize this strategy. Apple looked at the legal landscape and essentially chose to play a video game on hard mode for the final boss of the jury trial, just so they could unlock the absolute best weapons like uncapped contempt fines and lightning-fast discovery in level 1.
That is a brilliant analogy because choosing federal court is hard mode at the end of the game. By moving out-of-state court, Apple voluntarily gave up some massive, massive advantages they would have enjoyed if this ever goes to a final verdict.
Like what? What do they sacrifice?
2 major things. First, jury rules. Federal civil trials require 100% anonymity from the jury. Every single juror must agree.
That's tough.
Yeah, one single holdout juror out of 12 who thinks, hey, maybe OpenAI just built a better product, hangs the entire case. In California state court, you only need 9 out of 12 jurors to agree to win a civil verdict. It is statistically much easier to win.
Okay, what's the second thing?
Second, California has a very specific express evidence code privilege that shields trade secrets from being fully exposed to the public during a trial. Federal court does not have a direct absolute equivalent, which makes it much harder and riskier for Apple to present its deepest secrets in an open federal courtroom without them leaking.
Wow. So they made a massive calculated risk. But isn't there another huge risk looming over this whole strategy?
Which is?
Even by staying in federal court, don't they still have to face California's ultimate boss, that fiercely pro-employee mobility law, Section 16600, we talked about earlier? Just because they are in federal court doesn't mean California contract law disappears.
That is exactly the catch-22, and it brings us to the final, most complex phase of this analysis. The gray zone of mobility and the ticking IPO clock. You are entirely correct.
Okay.
Federal court or not, California's protection of employee mobility casts a long, inescapable shadow over this entire case.
Right, because the federal judge still has to apply California state law when interpreting the employment agreements that Tang Tan and Chang Li signed.
Exactly. And to make it even more explicit, the federal DTSA statute itself contains a specific provision stating that a federal injunction cannot prevent a person from entering into an employment relationship, and it explicitly defers to state laws that prohibit restraints on trade.
So what does that mean in practice?
It means Apple can get an injunction demanding files be deleted, but they absolutely cannot ask the federal judge to fire Tang Tan. They cannot ask the judge to bar Cheng Lu or any of those 400 former employees from continuing to work at OpenAI.
Which means the talent, that the human minds are still there. They're still sitting at desks at OpenAI, still designing hardware, still using their brains. Which leads me to the ultimate human question in all of this. If you have a top-tier engineer who spends 24 years at Apple working on the absolute most advanced consumer hardware on Earth, how do they physically, mentally separate what is a general industry skill from a proprietary Apple secret in their own brain?
It's so tough.
Like, can a master chef who has cooked a proprietary 3-star recipe every single day for 2 decades truly unmemorize it when they walk into a new kitchen?
The short biological answer is they cannot. The brain doesn't have a delete file function.
Right.
And California law implicitly recognizes this profound human limitation. That is precisely why, as we discussed, California flatly rejected the inevitable disclosure doctrine.
Oh, I see the connection now.
Yeah, the state made a philosophical and economic calculation. The macroeconomic benefit of allowing highly skilled humans to move freely and apply their accumulated expertise to new ventures vastly outweighs the risk that they might accidentally or even subconsciously use a fragment of a secret from their old job.
So you can't punish what's in their head.
You cannot legally enjoin someone just because their head happens to hold valuable secrets.
So Apple is walking an incredibly precarious tightrope. They have to prove that OpenAI isn't just passively benefiting from the accumulated experience of these 400 workers, but that they are actively, aggressively extracting tangible secrets from them.
Correct. Which is exactly why Apple's complaint is so heavily, almost obsessively laser-focused on the physical and the digital artifacts.
The laptops and files.
Right. Laptops kept after termination, downloaded a 1,000-page logic board PDFs, encrypted line messages, physical prototype batteries brought to job interviews, and third-party metal finishers. They are focusing all their firepower on the things and the documents because they know the law forbids them from touching the mind.
But let's look at the leverage Apple does have, because it's massive. They skip the state court to get fast discovery and the threat of terrifying, uncapped federal injunctions. Why the rush? Why does Apple want this resolved right now rather than fighting it out for years?
It all comes down to the ticking IPO clock.
Ah, the IPO.
Yeah. The CLG briefing expertly analyzes the immense, almost gravitational leverage Apple holds right now due to OpenAI's impending initial public offering. Remember, OpenAI is reportedly burning through cash at a historic pace to train these ASI models.
They need cash.
They need to go public to raise the billions of dollars in capital required to survive.
And when a company goes public, they have to file an S-1 registration statement with the SEC. And that document is scrutinized by every institutional investor on Wall Street.
Yes. And in that S1, SEC regulations mandate that you must disclose all material risks to your potential investors. You have to lay bare anything that could destroy the company's value.
So this lawsuit is a problem.
This massive radioactive litigation where a $4.6 trillion incumbent is accusing you of fundamentally stealing the foundational technology for your entirely new hardware division is a glaring, flashing red risk factor.
A huge red flag.
And it's not a one-time disclosure. Every single time OpenAI files an amendment to their S1 as they approach the IPO date, they have to publicly update the world and the SEC on the status of this lawsuit.
Which absolutely spooks investors. I mean, think about it. No one wants to buy into a highly anticipated IPO if there's a lingering threat that a federal judge might issue an injunction tomorrow morning that completely shuts down the company's new hardware supply chain or levies $1 million a day fine. It poisons the well.
Exactly. The financial and structural pressure on Sam Altman and OpenAI's leadership to settle this case, to make it disappear completely before they have to go on their IPO roadshow and answer questions from Goldman Sachs about stolen laptops, will be astronomical.
So what does Russo think will happen?
Jack Russo predicts in the briefing that this case will very likely follow the pattern of previous massive, high-profile trade secret clashes in Silicon Valley, like the Waymo v. Uber self-driving car case, or Apple v. Revos.
It settles.
It almost certainly won't go to a final dramatic jury verdict.
It's going to settle out of court in a closed boardroom.
Most likely. Russo predicts it will end in a highly structured negotiated settlement. And that settlement will likely feature intense forensic remediation.
What does that look like?
Independent third-party IT auditors will likely be granted full access to OpenAI's servers to hunt down and permanently delete any tainted Apple files. There will likely be strictly monitored compliance undertakings for OpenAI's future hiring practices to ensure they don't use Apple's code names or ask for prototypes.
Give him a check.
And inevitably, a very large check will be written to make it all go away.
A large check. A pound of flesh extracted. And Apple successfully protects its hardware mode for another day.
And that brings us to the final synthesis of this incredible briefing. We have traversed an amazing amount of ground today.
We really have.
We started with the macroeconomic stakes of the sixth industrial revolution, looking at how trillion-dollar titans are essentially warring over a few hundred specialized human minds.
Right, the talent war.
We examined the highly specific, alleged missteps of individual engineers, the sheer hubris of the LOL message on a company server, the audacity of the show-and-tell interview sessions with physical prototypes.
We explore the institutional allegations, diving into the Michelin star Wagyu heist of the metal finishing supplier sting, which just reads like a movie script.
Totally.
And we unpack the strategic genius of Apple intentionally choosing hard mode by avoiding California state courts just to unlock uncapped federal contempt power and bypass years of discovery delays.
It is genuinely a masterclass in modern high-stakes bet-the-company litigation. But I want to leave you, the listener, with a final, somewhat provocative thought to ponder long after this deep dive ends.
Okay, let's hear it.
We have spent this entire time dissecting OpenAI, whether they stole these secrets, how they allegedly architected the theft, the culture of their recruiting, and how they will have to defend themselves to save their IPO. But consider for a moment what this massive, aggressive lawsuit says about Apple.
Okay, that's an interesting flip. I'm listening.
If an incumbent titan, a company with $4.6 trillion in resources, decades of absolute market dominance, an unparalleled global supply chain, and thousands of patents, if a company of that unimaginable size believes that its continued survival to the year 2076 relies on launching incredibly aggressive, bruising federal litigation against its own departing employees, does that signal unshakable strength? Or does it signal a quiet existential panic echoing within the halls of Cupertino? Does it suggest that they secretly realize their human capital, the brilliant, messy human minds that are currently walking out the door, and not their vast patent portfolio or their cash reserves, is the only true, irreplaceable competitive moat they have left?
Wow. That is a chilling thought. If the umpire's only viable defense mechanism is a lawsuit to slow down the people who built the umpire in the first place, how long can the umpire actually hold the walls? It really reframes the entire conflict from a story of theft to a story of desperation.
It certainly adds a layer of existential dread to the legal maneuvering. It's a fascinating time to watch this industry.
It truly is. And as we close out today's deep dive, I have an important note to share regarding the source material that made this analysis possible. Led by Jack Russo, Computer Law Group, LLP, is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available commitment-free with no paywalls or other charges.
Readily available for anyone who wants to dive deeper.
So, returning to where we began, when you step into the muddy, deeply human waters of talent migration and trade secrets, that clean, binary X-ray machine we expect the law to provide is truly broken. We're looking at a complex, shifting landscape of innovation where the lines between a coach's innate skill and a stolen, printed playbook are blurred beyond recognition. Thank you for taking this deep dive with us today. Keep questioning the headlines, keep looking at the underlying incentives, and we will catch you next time.
Tune in next time on The Valley Current.